But when an Italian tells you you're a part of a family, that is something completely else. You are the most polite actress I have ever met in my life. Also, I want to tell you that I've learned so much from you on set, and because you made me grow up so much, and I love you like crazy. Crazy. I swear to God.
I'll give you the money for that later.
Yeah,
that was
thank
good. Good work. Good work.
It was 1,000.
When Bryan, Freedman and Wayfarer Studios filed their response to Blake Lively's sanctions motion, they didn't just defend themselves. They absolutely destroyed her legal strategy with surgical precision. For months, people have been asking where Baldoni's team's backbone was, while Lively's lawyers hurled accusations and demanded sanctions. Well, they just found it. And what they revealed about Blake Lively's legal tactics is absolutely jaw-dropping. Lively's team had demanded sanctions against Freedman, claiming he was engaged in a public relations stunt that could sway the jury pool.
Baldoni's motion is just a PR stunt. Nothing infuriates me more than when these privileged Hollywood Nepo babies come together to abuse the Me Too movement and overreact and cry victim. Yeah.
They wanted him publicly reprimanded, wanted attorney fees, and basically wanted him silenced. But Freedman's response didn't just deny these claims, it exposed the massive hypocrisy at the heart of Lively's entire legal strategy.
New name is Isabel Farad.
It's ridiculous.
Farad. What a fraud. And again, look, she's a young woman and you make mistakes. She's only 24 or something like that. So
26.
I want her to be forgiven after she does the right thing, and that is come forward and apologize.
Billy, I love you. But if one more person calls that girl young and naive and she needs to be forgiven, I'm going to crash out. That's a grown woman. She could vote. She could go to war. She could get a rental car. She's not a young woman. She knows what she's doing. And so right now, Justin is giving her a way out, which is more than I would offer her. He's saying, you know what, if you don't want to be in this mess as much as you say you don't want to, if Blake agrees to leave you out, I won't touch you. I won't use your messages. I won't use your communication. I won't use anything. I can wash your hands off of this and you can go away. And I wouldn't have offered her that. And he's still being kind. I would drag her through the mud. Come on, let's go.
The filing, crafted by legal powerhouse Janine Ellen Garup, systematically dismantled every argument Lively made. They pointed out that Lively was citing 10 statements from Freedman as inappropriate, while her own team had made over 14 inflammatory statements to the press. The irony was thick enough to cut with a knife. But here's where it gets really interesting. Freedman's team didn't just defend their statements. They documented every single inflammatory comment Lively's representatives made to major outlets like Deadline, Entertainment Tonight, and CNN. We're talking about statements that painted Justin Baldoni as a serial abuser, a fraud, and someone who weaponized his feminist advocacy as a cover for predatory behavior.
Now the internet's using her words against her and saying, no, we should believe women. From the very beginning, we've been told by Blake Lively supporters that we should believe women. Isabel Ferrer said Justin Baldoni created a comfortable and safe space for her. I believe her. Isabella Ferrer said Justin Baldoni created a welcoming environment. I believe her.
What makes this response so devastating is how it exposes the strategic manipulation behind Lively's messaging. Her team wasn't just defending her claims. They were deliberately weaponizing the language of sexual harassment survivors to create an environment where questioning her story became morally reprehensible.
Leave it up to these snooty, uptight celebrities to play their perpetual damsel in distress. Maybe everyday women are just built different, and these whiny bitches need to grow a backbone, or they're Nepo frauds pretending to cry victim to take advantage of people's good nature and manipulate them into siding with them as the performative victims in this scenario. This is why so many women, especially those who have survived real harassment and abuse, are standing in solidarity with Baldoni. Stop dramatizing, overreacting, and calling everything harassment.
Look at the pattern in their statements. Every single press release framed this as a classic case of victim blaming. They used phrases like, "This is an age-old story," and referenced Darvo tactics. They claimed anyone doubting Lively was just perpetuating harmful stereotypes about women who speak out. It's textbook psychological manipulation, designed to shut down critical thinking. The most disturbing part? Lively's actual complaints to Sony during production were incredibly limited compared to what she claimed publicly. According to the unsealed documents, the only formal complaint she made was about Baldoni calling a character's outfit sexy. That's it. No complaints about unwanted kissing, no reports of inappropriate touching, no HR documentation of the serious allegations she later made public. But that wasn't the narrative her team pushed to the media. They painted a picture of systematic abuse, retaliation, and a coordinated smear campaign. The disconnect between her documented complaints and her public accusations is staggering. Freedman's response highlighted something that should make everyone uncomfortable about this case. Lively's team made statements calling Baldoni's work for women's rights a fraud, claiming he was a typical serial abuser and suggesting he was using his platform to prey on women. These weren't measured legal responses. These were character assassinations designed to destroy someone's reputation before any trial. Meanwhile, they demanded sanctions against Freedman for statements, like questioning whether Lively would show up for her deposition and calling her a Hollywood elite. The contrast is absolutely mind-blowing. One side is making accusations of serial abuse. The other is making factual observations about deposition scheduling and celebrity status. The legal filing pointed out that Rule 3.6, which governs attorney statements to the press, specifically allows lawyers to respond to adverse publicity not initiated by their client. In other words, when Lively's team launched their media blitz painting Baldoni as an abuser, Freedman had every legal right to defend his client publicly. Even more damaging, they quoted the judge's own words from a July hearing where he explicitly said attorneys in high-profile cases have a right to speak to the press and give their interpretation of events. The judge literally said he wouldn't begrudge either side speaking to the media given the public interest in the case. Perhaps the most calculated aspect of Lively's strategy was the attempt to drag Taylor Swift into the controversy. Freedman's team documented how Lively's representatives repeatedly referenced Swift in their statements, clearly trying to weaponize her massive fan base against Baldoni and Wayfarer Studios. They issued statements about how Baldoni's team was exploiting Taylor Swift's celebrity and trying to drag a woman who has been an inspiration for tens of millions into the case. But here's the twist. The court documents revealed that it was actually Lively's crisis management team that first included Swift in their scenario planning documents back in August 2024, long before any legal filings. This isn't just about celebrity name-dropping. This is about jury manipulation on a massive scale. By repeatedly invoking Swift's name and framing any legal action involving her as harassment of an inspiring female figure, Lively's team was attempting to prejudice millions of potential jurors who are Swift fans. The subpoena controversy around Swift revealed the strategy even more clearly. When Baldoni's team withdrew subpoenas related to Swift, Lively's representatives immediately claimed victory and painted it as Baldoni's team folding under pressure. But the reality is more complex. The subpoenas were likely withdrawn not because of public pressure, but because they weren't necessary for the case. What makes Freedman's response so devastating is the systematic documentation of Lively's media campaign. They didn't just claim she was running a PR offensive, they provided receipts. 14 separate statements to major media outlets, each one designed to frame the narrative in her favor and paint Baldoni as an abuser. The statements follow a clear pattern. First, they frame any legal action against Lively as retaliation against a sexual harassment victim. Second, they invoke survivor language and post-Me Too talking points to make questioning her claims seem morally wrong. Third, they attack not just Baldoni, but the laws and legal processes that allow defendants to defend themselves. One particularly manipulative statement claimed that Baldoni and Wayfarer were attacking the laws that are designed to protect victims of sexual assault. This isn't just legal defense. This is systematic manipulation designed to make the legal system itself seem complicit in victim blaming if it doesn't immediately rule in Lively's favor. The filing also revealed how Lively's team tried to frame routine legal procedures as harassment. When Baldoni's team subpoenaed documents and witnesses, Lively's representatives painted it as bullying tactics and an attempt to overwhelm the public's understanding of the case. Freedman's response didn't just defend his statements, it exposed the fundamental legal principle that Lively's team was trying to undermine. In the American legal system, both sides have the right to present their case publicly, especially in high-profile matters where media coverage is inevitable. The filing quoted established case law showing that statements made years before a trial are extremely unlikely to prejudice a jury pool. Courts across the country have ruled that attorneys speaking to the press about ongoing cases is protected speech, particularly when they're responding to adverse publicity initiated by the opposing party. More importantly, they demonstrated that Freedman's statements fell within the express exceptions to Rule 3.6. When Lively's team launched their media blitz painting Baldoni as an abuser, Freedman had not just the right, but arguably the duty to defend his client publicly. The judge's own words supported this position. By explicitly stating that attorneys in high-profile cases have the right to speak to the press, and that the public has an interest in hearing both sides' interpretations, the court had already established the standard that Lively's team was now trying to change. What's most disturbing about this case isn't just the specific allegations or legal maneuvering, it's the precedent it sets for how sexual harassment claims can be weaponized to shut down legitimate legal defense. Lively's team didn't just make allegations. They created a narrative framework where questioning those allegations became evidence of victim blaming, where normal legal procedures became retaliation, and where defending against defamation became proof of guilt. This strategy doesn't just hurt Baldoni. It potentially damages every future sexual harassment case by creating a template for manipulation that undermines legitimate victims. When survivor language gets weaponized for strategic advantage, it makes it harder for real victims to be believed and supported. The filing highlighted how Lively's team repeatedly used phrases like "believe all victims" while providing no evidence for their most serious claims. They invoked post-Me Too rhetoric not to advance women's rights, but to create a legal environment where their opponent couldn't effectively defend himself. Now the question becomes how Judge Louis Lyman will respond to this comprehensive takedown of Lively's sanctions motion. The judge has already issued orders requiring all parties to use respectful language in their filings, but Freedman's team made it clear that if sanctions are warranted for anyone, it should be Lively's lawyers. The response essentially dared the court to apply the same standards to both sides. If Freedman's statements questioning Lively's credibility warrant sanctions, then surely Lively's statements calling Baldoni a serial abuser should face the same scrutiny. The filing also put Lively's team on notice that any future disrespectful or inflammatory statements in court documents could result in sanctions motions against them. After months of one-sided attacks, Freedman's team made it clear they're no longer playing defense only. Baldoni's $400 million countersuit was dismissed by the judge, who ruled that statements made in court filings are generally exempt from defamation claims. But this sanctions motion fight is different. It's about conduct during litigation, not the underlying claims. This legal battle has implications far beyond Blake Lively and Justin Baldoni. It's become a case study in how modern celebrity culture, social media manipulation, and legal strategy intersect in dangerous ways. The systematic documentation of Lively's media strategy reveals how sophisticated modern PR campaigns have become. This wasn't just damage control or reputation management. This was strategic narrative warfare designed to win in the court of public opinion before any legal proceedings could run their course. The weaponization of survivor language and post-Me Too rhetoric represents a particularly troubling development. When legitimate concepts designed to protect victims get turned into tools for strategic manipulation, it undermines the very movements they claim to represent. For content creators and media outlets covering these types of cases, Freedman's response provides a masterclass in how legal teams can systematically document and counter media manipulation campaigns. The methodical approach to cataloging opposing statements and demonstrating double standards could become a template for similar cases. The case also highlights the challenge judges face in high-profile litigation, where both legal and media strategies intersect. How do you ensure fair legal proceedings when both sides are actively trying to shape public perception and potential jury pools? Ultimately, this response from Freedman and Wayfarer Studios represents more than just legal defense. It's a comprehensive exposure of how modern celebrity legal warfare operates, and it reveals disturbing patterns in how serious allegations can be strategically deployed for maximum public relations impact rather than pursuit of justice. The question now is whether the court will recognize the manipulation tactics documented in this filing, or whether the strategic use of survivor language and victim rhetoric will continue to shield Lively's team from accountability for their own inflammatory statements and legal conduct.